attendance of
Hello, Nkululeko, are you there?
Yeah, Chair.
All right, let's get going. We're at 9 o'clock. Welcome, everybody. In particular, we welcome COSATU's Matthew Parks, whom we know and he knows us. But we have only one submission. It's 75 bill, so that's understandable. Well, not understandable, but that's the norm, it seems. So basically, you have the program before you. And all it behoves me to say is welcome, Matthew, and everybody else. I hope you and your families are safe in the horrible circumstances we're stuck in. And may I hand over to you, Matthew? 15 minutes or so, is that okay? Matthew? Is Matthew here in Nkululeko?
Yes, I admitted him.
Oh, brother, he doesn't seem to be on my list of participants. I think he fell away.
Yeah, he's here.
Oh, well, what's happened? Can you... I see he's there on the screen now. Matthew?
Let me try him on the side, Chair.
Please do. Colleagues, we also have the program for this quarter. As you know, it's the typical program. We have a good chunk of the period consumed by the budget, obviously. And apart from that, we have this poll. And then we will deal with other matters as well, such as we have to. But basically, we're expecting the NA to process several bills, and they haven't got their program together through their committee yet. I think the committee meets today. So once they let us have their dates of their voting on bills, then it's easier for us to set a clearer program than we currently have. But while we're waiting, can I ask that we look at the program? Do colleagues want to say anything about the program? It was sent to you again last night. Any comments?
Chair, if I may, I think yes. Thank you for getting it out so quickly. I also noted that the ATC list had been updated extensively, well in time, helps us with our planning. I see no issues with the program as it stands at the moment, and quite happy. Thank you.
Yeah, it's a standard program. We don't have much of a choice. Remember, we can only proceed with bills if they come to us from the NA. And, you know, I will speak to my colleague that we have need clearer guidelines on when they intend to finalize bills, because that means we can plan ahead. So I'll engage with him around that. But they're only getting into motion, I think, today. So we'll follow up with them, and our committee secretary will follow up with Alan. In Nkululeko, can you get the program from Alan for this quarter? Okay. And then forward it to me, and I'll have a look at that. All right, colleagues, in that case, can we have a mover and a seconder for the program? It's not incontroversial there. We can always, remember, colleagues, we can always change it. We've never had much of an issue, as far as I can remember, about the program. It's the sequencing sometimes we don't agree on. But to have the issues on the agenda, it's usually fun. So there we are. Is somebody going to move and somebody second the program so we're done with it?
I move, Chair.
Hi, Dikeledi. Nice to
Hi,
meet you.
guys.
Good.
Thank you.
And seconder, please.
Muletsane, Chair.
Okay, my brother.
Yeah,
nice to hear you too.
Straightforward, I second.
Yeah, it's a normal thing. There's nothing ideological here. So there we are. It's done. Now, can I ask, is Matthew connected now? Ah, there we are. Okay, Matthew, fine, go ahead. You've lost about 4 minutes of your time, but since you're COSATU and I'm terrified of you, we'll let you have your 4 minutes back. Matthew? We're missing your voice.
Apologies, Chair. My apologies, Chair. I just had a bit of computer.
Oh, fine. Okay, you're here. That's all that
Technological
matters,
issues.
that you're wearing the right colors. Unlike Mr. Ryder there, the Honorable Mr. Ryder. Okay, go ahead. Thank you.
The question, Comrade Chair, should be to the Politburo member of the Vanguard Party. Why is he not wearing red?
I'm environmentalist to please my daughter.
No, thanks very much, Comrade Chairperson, and good morning to honourable members, and compliments for those who have not seen yet this year. I think thanks to members to give us space as COSATU just to raise our views, our support, and also two proposed amendments we wanted to make around this bill. I think we can go to the next slide, Nkululeko. So I think, Chair, just important to give a bit of context. So we're approaching as COSATU this bill as a critical tool in the fight against corruption and state capture. I think we've all seen the devastating impact that state capture and even corporate capture has had on the economy, on the state and society and workers. And I think amazingly, Comrade Chair, we've actually not held auditors accountable for their role in this state and corporate capture, because all of these state entities, enterprises, and private companies on the JSC have auditors, and they have facilitated at times and participated often in state capture and corruption. Chair, we thought this bill was a useful tool to try to address some of the existing loopholes in the legislation, to update it, and I think significantly to empower URBA, which has got a critical oversight role to play. So we support the bill as a progressive intervention, and many of its provisions are quite correct and quite progressive, and hence our support. We do have two concerns around two weaknesses in the bill that we feel should be addressed. And so we've got two proposed amendments. But I think in essence, Chair, we support the bill. We want to see it being amended slightly and then to be passed by Parliament and to be prioritized for implementation. Next slide. So, Chair, I think, again, just to emphasize the legacy of some of these auditors who have basically betrayed the country and abused their fiduciary duties, etc. We all know the Auditor General tells us that we lose about 10% of our budget every year to corruption, wasteful and irregular expenditure. That's 150 billion rand. We all know the consequence of that. We've seen the collapse of good governance in many SOEs, which has a devastating impact on the economy. Not only have we seen the collapse of SOEs, but we now see municipalities which can't pay workers. The case of Amatole is a case in point, but there's also many others which don't even make the headlines. We've seen the collapse of many departments, especially at a provincial level. And of course, Comrade Chair, we all know what's the impact to service delivery, the crisis is causing for the fiscus. And of course, at the end of the day, those who pay the price are first and foremost workers. Workers at the parastatals which have been retrenched, workers in the private sector who have lost their jobs. But of course, even these many private sector companies are often funded by workers' pension funds. The PIC, for example, is invested in many of these listed companies where they've played very fast and loose with fiduciary duties and good governance. And again, workers have footed the bill. So I think we really need to look at the complicity of auditors and look at the consequences for them. Next slide. So, Chair, the provisions we're supporting the bill, I think number one is a criteria upon which you can serve on URBA and its investigative and disciplinary committees. We think the prohibition of practicing or registered attorneys from serving there is critical to avoid conflicts of interest. Yes, you need former auditors, but you don't want ones who are currently practicing. I think it's also quite useful, Chair, to prohibit specifically members from holding shares in auditing companies, receiving payments of any sort from them as well, just to make it very clear so we can provide very strict separations. Next slide. Chair, the search and seizure provisions we support fully. We think they are bold and correct. You need to capacitate URBA, so we need to retain these provisions. And we're saying also deliberately, Comrade Chair, because in the previous public hearings in last year in the National Assembly, there was a significant resistance from some in the auditing industry who were opposed to these search and seizure provisions. Our position, Chair, is that these are in line with the normal legal norms. You need to capacitate URBA. Those who have got nothing to hide should not mind opening the books. And that's the very essence of what it is meant to be an auditor, that you are transparent, etc. You should not be hiding. And again, Chair, the consequences of not doing it are devastating. And of course, Comrade Chair, we don't think we need to handle people who loot with kid gloves. We need to be very firm and rough with them. Next slide. Chair, we think the provisions for disciplinary procedures in URBA are useful. We think it might help to reduce the often lengthy delays in some of the proceedings previously. It is quite useful, Chair, that the bill specifically opens up these hearings to the public for scrutiny. And that also helped to shine a bit of media spotlight on them as well. But I think we might need to just kind of tighten some of the timeframes in the regulations to avoid inordinate delays at times. Next slide. Chair, the sanctions also we think are fairly useful, but we are a little bit concerned. It doesn't need to be addressed in the bill, but more in the regulations, as the bill provides for the Minister Finance and Treasury to set fines. But we have seen instances previously where some auditing firms, in essence, got a slap on the wrist with minute fines when you compare it to the profits they've made. We think those fines should be significantly increased and possibly look at additional sanctions to be effected as well. But that can go into regulations. Then, Chair, there are two proposed amendments. The first one, sorry, is now on page 4, I think clause 7. But basically, there's a deletion of the wording in the Act, which required URBA to meet at least 4 times a year. In the previous version of the bill, that was reduced to 2. And I see now in this version of the bill, it's been deleted completely. We think that's a mistake, Chair. If you set the bar low, then we must not be surprised when nothing is done. How would you hold somebody accountable if there's no guideline to hold them to account? We think given the critical role of URBA, especially dealing with corruption and state capture, in terms of cleaning up the sector, which is still needs a lot of work, we should retain the existing provision in the law, which requires URBA to meet at least 4 times a year. Yes, we don't want to micromanage people. They can meet more, but at least a minimum level of requirement. I think, Chair, we've learned in the last decade not to assume anything in government. And hence the need to state things very, very clearly and hold people to account. So we're fearful that if you delete this clause, delete the requirement for 4 meetings a year for URBA, that'd really be extremely reckless in the era of state capture. And since now we operate in a virtual world, the logistics of holding 4 meetings a year is really quite easy to do. Next slide. Chair, our second proposed amendment, there's an internal rule in URBA where it requires a mandatory rotation of auditing firms every 10 years. We think it's a progressive, it's a correct rule. You need to prevent an incestuous profit interest developing between the auditing companies and the company they're meant to oversee. You don't want a situation where auditors are fearful of rocking the boat because they might jeopardize a lucrative contract that their company has with this company. So, Chair, we think that rotation rule of URBA is correct, but we're fearful that it's simply an internal rule and hence not a law. It can be changed if down the road dubious elements do come to power at URBA or the significant pressure from the auditing firms, etc. So we think Chair should be elevated to be part of the bill so it can be put there in law and then it's mandatory and it cannot be changed easily. If we simply leave it as an internal URBA rule, then we should not be surprised when down the road a future board just simply chooses to delete it. And I think we have seen in the past year or so some worrying media articles about governance issues at URBA. We saw the Minister of Finance replacing the board recently. So hence we feel this is quite a critical rule, Chair. We had raised this in the public hearings in 2019 before the elections. We had raised it again last year in the National Assembly in public hearings. And it was a bit worrying for us, Chair, when Treasury responded to say, well, we can look at that in a future amendment bill. Our fear, Comrade Chair, is that if you do that, we all know, and you would know better than many of us, how long it takes for bills to reality. My rule of thumb is it takes about 5 years for a bill to leave a desk in a department to being signed into law by President and by being implemented by department. So this for us is such a critical thing. We think it should be put here now, rather do it properly now than to wait another 5 years or even longer. Next slide. So yeah, Chair, so I think for us, this is quite a critical thing to clean up corruption. I think I've covered these issues, so you can go to the next slide. So just the last few issues, Comrade Chair, I think some related matters. We do appreciate the fiscal pressures government is facing right now. And of course, government is reducing them allocations giving to all state entities and departments, etc. But we are worried at times if we cut too much from critical anti-corruption institutions like URBA, we might pay the price. We think URBA is a relatively small entity. We should make sure it's adequately resourced, given the serious task it has. And the consequence, if you don't do that, you might actually pay much more in terms of allowing corruption to continue. Chair, I think we might also want to look in future at possibly expanding the legislative oversight mechanisms to include auditing committees as well in both the public and the private sector. And these are, fall slightly outside of the current provisions. The next slide. So in conclusion, Comrade Chair, I think for us, this is a useful bill. It comes in the context of state capture, where auditors were really at fault in many instances. I think right now we're seeing how we're paying so heavily for that mismanagement, that looting, etc. So this is for us a progressive bill. In particular, we want to defend the search and seizure powers, to retain them. But I think for us, Chair, just the two proposed amendments about retaining the existing criteria for the URBA board meetings to meet at least 4 times a year, and to see about inserting a legislative requirement for automatic rotation auditing firms every 5 years. But yes, in support, Comrade Chair, we support the bill, and we're looking forward to being passed and implemented into law. So yeah, thank you, Comrade Chair. I hope I kept to the time frame. Thanks.
Well, you didn't even use your full 15 minutes. Regrettably, you can't carry that over to the next hearing if you're running out of time there. I don't see why not, but anyway, I don't make the rules of parliament, although to create the norms. Now, the National Treasury, do you want to reply to Kusatu before we open up the discussion? In particular, you can respond to the overall submission, but in particular, the 2 provisions about URBA meeting 4 times a year and having the mandatory rotation of auditors in the law rather than an internal URBA policy. Who's here from National Treasury, please?
Good morning, Chairperson. MP van Schoor.
Oh yeah, MP, of course. Welcome, MP. Long time no here.
Oh. Yes. Yes, thank you very much. We'll respond to the 2.
Can you put your video on? The person that speaks is normally asked to do that.
I did put it on. Can you see me?
No, I can see a blob of a human being. It looks very male to me. It's like a ball, and then below it are shoulders.
So yeah.
These don't look like your shoulders for sure.
I tried it again.
Can you help in Kuleleko?
It actually shows on my side that it's on.
So it's an IT problem. In Kuleleko, you're on, my friend.
Yeah.
Yeah, can you help? And I'm seeing Fani's face. Fani, why are you intruding, right?
She's there next to Fanny.
MP is visible. He doesn't have a single court in law, but he wants to
She's next to Fanny.
Oh, she's next to Fanny. Oh, Fanny didn't do that. He's not trying to prepare for the local government elections and profile himself at every opportunity. Oh, okay.
Sorry.
She's there, Chair, next to him.
Okay, thank you. May I proceed?
Yeah, I don't see on my screen, but maybe it's on my side. Something's wrong. All right, go ahead.
Yes, I can see it.
There you are. There you are.
Okay. The first matter is the issue of the meetings of the URBA board. I just want to explain the amendment that was introduced in the National Assembly. The amendment was to the section that deals with committee meetings. And it proposed that the committee meetings be reduced from at least 4 to 2. So it was not a change to the number of board meetings, which is dealt with in a different section, section 15. But now, if you look at the bill that's now before you, it's in clause 5, which amends section 20 that deals with committees. We now, in the National Assembly, Treasury's response was that we support the comment of Kusatu in respect of committees that it shouldn't be reduced to 2, so it remains at 4. So what it says now, and I know it's a bit technical, but when we do the clause by clause, we'll explain. There was actually a mistake in the original act because it repeated provisions that were already there. The committee section provision applies to provision that's applicable to the board. So the board provisions say they must meet at least 4 times a year. And the way it's now in the bill that's before this committee it will mean that they'll meet at least 4 times a year. We just proposed that the latter, at the end, it say except blah, 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 that be removed. So it's, in our view, it's now clear that both the board and committees must meet at least 4 times a year. But the only proposal we made that was rejected by the National Assembly is that the committee meetings must be reduced to 2. So that's the first area. Then on the mandatory rotation rule, I just want to explain, I read the COSATU submission, and obviously they did raise it when the bill was before the Standing Committee of Finance in 2019. When we reintroduced the bill, we didn't make any changes, and that was to insist to expedite the processes within government to get the bill through cabinet, etc. So we didn't go through another public comment process. So what we indicated, as Mr. Park said, we indicated that this will be part of future amendments, because there's other amendments that also was raised in the public submissions about including accountants, and now also there's now a proposal that we look at auditing committees in the private and public sector. That in respect of the mandatory rotation rule, I think it's important to note, I think it's more than just an internal rule. It's something that's issued under rules by IRBA, and it's published in a gazette, and they must follow a public comment process when they amend any rules or make new rules. So it's not, I do understand that the power lies with IRBA to make a decision on whether to change the rule. But that we do think it's important that before we introduce or propose that this become a provision in the Act, and maybe reduce the period from 10 to 5, that we subject that to a public consultation process before we come back to Parliament. So that's our view on the mandatory rotation rule. I don't know if IRBA, Gillian Bailey is also in the meeting, if she wants to add to my input on this in this regard. Gillian?
Yeah, I think she should actually. I was about to ask what's IRBA's response. So if she's here, can you go ahead, Gillian?
Thank you, Chair. I don't have anything further to add. On the mandatory audit firm rotation, I think it's going to take us a while to go through the formalities to get that included, and it'll just delay the implementation of these other urgent criteria, which we have had tabled for quite a while now. So yeah, the committee meetings, as MP has explained, it is clear that it's a minimum of 4 for all committees in the new version of the Act. But we're not yet ready to include the mandatory audit firm because it'll delay the current Act.
Okay, so anything else you want to say, Treasury? No. All right.
No,
so let's throw it open to the floor, as it were. Who wants to speak?
Mr. Ryder, Chair.
All right, Mr. Ryder. I see Mr. Ryder. Okay, go ahead, Mr. Ryder.
Thank you very much, Mr. Karim. Yeah, thanks for the presentation, Mr. Parks, and the response, Treasury. I mean, it's not a technical question. The question is it 2 or is it 4? So, you know, we've settled on the fact that it's 4 now, and as long as that's clear and that there's no room for any kind of, you know, befuddling or messing with it, then I'm comfortable with that. The comment on the mandatory rotation, and I want to pick up on a couple of comments that Mr. Parks made, and the issue is that there is currently a regulation or a rule that's being brought in about mandatory rotation. And, you know, Mr. Parks pointed to the fact that, you know, if there's a change of guard at IRBA, then, you know, it may cause problems, blah, blah, blah. Look, I think the fact that it's a regulation that we're moving towards formalizing it in the next version of the Act, I think leaves me with a certain degree of comfort. I think we agree on the point that the rotation is necessary. I think the introduction of that, as was mentioned now by Ms. Bailey, the introduction may take a little bit of time, and so yeah, to have it kind of introduced more softly, I suppose, is great, and probably preferable. But yeah, what I want to pick up on Mr. Park's comment about the change of guard at URBA, and the fact that, you know, we don't know who the individuals are going to be or what their leaning is and so on. And let's look at this act and the importance of it. And I think everyone's in agreement. We want to push this act through as fast as possible, you know, without compromising quality, but getting the thing through so that we can implement the changes that are proposed. Because the role of auditors has always been, you know, one of being the oversight body. They've always been the kind of gold standard of truth and disclosure. And yeah, I mean, Matthew spoke about transparency, but I also want to talk about dependability. You know, if the auditor said something, you could always stand by that. That has not been the case in the last few years, and the auditing profession has brought themselves into disrepute. And not just one or two of them, there's a number of them that have done this, and they've hurt their own image. Now, for URBA to sit over this, I think is obviously a massively important role. And yet now we are seeing in the media, because I mean we can't forget, Chair, that you know, things are happening and we live in a dynamic world. And if one looks at the media at the moment, there's a lot of noise around URBA and what's happening there at the moment, in terms of yeah, you know, the change of guard. And of course, the minister has just gone and disbanded the board and is going to be reconstituting one. And in terms of this, you know, I think that the minister has extensive powers and with little oversight over his appointment of who sits on that board. Now, I'm not sure if, yeah, I see Advocate Jenkins is online today. Perhaps he can guide us a little bit on this and just talk to the fact that, you know, in terms of the importance, as Matthew pointed out, the importance of the role of URBA and the appointments and the changing of the guard there. You know, I mean, you can go and appoint a bunch of high school students there if you really want to cause trouble in this profession. So in terms of oversight over the minister's appointment, I do know that things like the SABC board, for example, there's a parliamentary oversight role where actually they get involved with the interviewing of the candidates, etc. And I know that that's repeated in a number of these types of entities that sit within departments. Maybe we can just get some guidance on, you know, when does a minister have the authority to just appoint at his own free will without oversight, and when does Parliament have a role to play? Is that something that needs to be included in a bill? And perhaps, you know, we need to think about including that, if not in this version, certainly and most definitely in future versions to come. Thank you, Chair.
Yeah, anybody else? I don't see any other hands up in Kululeko. No, all right. In that case, look, firstly, you know, I don't think we should have study groups on matters that are straightforward, but nothing stops a party study group from saying its representative who spoke in a committee meeting did not speak for the majority, and we can change it. There's no problem. Nobody, including the chair of a committee, can act outside of a majority decision. So you know, unless that decision goes against the rules of Parliament or the Constitution. But you know, these are straightforward policy matters. So the first issue is, I take it all of us agree that the board should meet 4 times a year. In fact, if you think the events of the last year and more, and indeed the year and globally, and indeed, you know, what's happened to the URBA board reinforces the need for that. So nobody's questioning that. So the only thing that remains there, Matthew, is that you can monitor things. You know, we will hopefully, because there's so little to consider, in the next meeting or the meeting after that, finalize the bill. So you can monitor that and keep in touch. So on that matter, there's no dispute or no disagreement. So all we want from Treasury is clarity that indeed the board can meet and the committees at least 4 times a year. So that matter is a policy matter that I think all parties agree on. The second one is the mandatory rotation of firms. Now, as I recall it, Frank, MP, this was brought to Parliament. We had public hearings. We had some difficulties with the way URBA was doing this. But finally, we said, okay, fine. So it's more than just an internal rule because it came to Parliament. Now, Frank, can you remind us in respect of what? Is there something in the bill that says all regulations that URBA decides on have to be brought to Parliament? Because I know they gazetted it, URBA did, but we still had public hearings. And they were quite vigorous public hearings with most auditors opposing it, needless to say. But interestingly, the Auditing Association also, with the previous Auditor General himself representing it, opposed this at that time. So firstly, I'm not so sure, maybe Frank, MP, you can help us, whether this is like just a normal internal rule that can be dispensed with by the board without going back to the public. So the first question I have to the lawyers, Treasury and our own, is can the URBA just dispense with it? That's the first thing. Secondly, the rotation of auditors, actually we dealt with this at great length. And you see, from what we understood, but maybe Kosato has more insights, I don't know, the sense we had was it takes an auditing firm several years to adjust to a company whose books they're auditing. And, 5 years, it seems to me, may not be enough, and it can be disruptive. So we need to find a balance, Matthew, between avoiding, these disruptive changes too soon, with the need to ensure rotation so that nobody gets complacent and becomes pally-pally with the company and overlooks its wrongdoing. So personally, I'm not so convinced about 5 years, but what I do feel personally, I don't know whether the majority will agree, I don't see a problem, actually, Treasury, in it being put in the bill. As far as I know, Frank, is this of the magnitude that would require public hearings? So in any case, this is a public hearing, Frank. So if we decided to agree with Kosato, would that be legally tenable? Or is this not seen as what you call amendment that is germane to the consideration of the bill? It's something completely new. There have been different legal interpretations, new colleagues, about how far a committee can go. If it has an amendment bill before it, can it introduce a totally new amendment which has not been canvassed in the public domain? Now, this gets complicated, Matthew, because we have Section 75 here and we the NCOP. So personally, I don't see a problem, National Treasury. If URBA's got it as what is a semi-regulation, more than a normal internal rule, like meeting at 5 o'clock on every, or say, something like, okay, we meet 4 times a year, at least once in each quarter. And if it's the last Friday of this particular month, every 3rd month, starting at 10. Now that they can dispense with and say, we'll start at 9. But this is of a different magnitude of an internal rule. Am I right? And can URBA just go ahead and do it without public consultation, dispense with this 10-year rotation? And secondly, I mean, look, MP Frank knows, those of us who've been around a long time, how long it takes for bills to come. So I don't find that very convincing, MP. The only restraint I have is that, obviously as NCOP, We have to win our colleagues over from the NCOP side. So in short, my own view is that it should be in the law, actually. That's my view tentatively, unless I'm convinced by a majority otherwise. Then there's the issue of having oversight over private and public auditing firms. Now, that's a matter I don't think we need to discuss now because it's not before the bill, but National Treasury colleagues, you need to think about this. What are we actually saying? We're going to bring all these committees before us, auditing committees. Now, National Treasury, you appreciate that as it is, the Money Bills Act is so demanding on these two committees, appropriations and finance. How are we going to do that? Moreover, what auditing and forensic capacity do we have? So we need to think about this. It's fine. I think we should do it, but it should be a separate committee, and they have to be appropriately capacitated. Otherwise, what you're going to have is like formal oversight, Matthew. And, you know, those people are so technically sophisticated compared to your average MP and the staff we have at our disposal, with due respect to the staff. But I mean, you know, we're not 30 years and 40 years, our staff, auditors, you know, we don't have qualified auditors. In fact, none of our staff members is a researcher or content advisor, is an auditor as far as I know. So there's no use doing this thing unless you capacitate Parliament to do it. Otherwise, it almost becomes a rationalization for wrongdoing, because people say, oh, we appealed before Parliament, they saw nothing wrong. And so what's the big deal when they get attacked in the media or by unions or by other civil society structures? So that's my tuppence worth. Anybody else in the meanwhile wants to say anything? I don't see anybody else in Kulileko, in which case, shall we move on then, colleagues, to hear from Treasury, I mean, from COSATU and then Treasury.
Okay, no, thanks, Honourable Chair, and to Honourable Members. I think it helps, Comrade Chair, that Treasury has a kind of cleared up the issue about the four board meetings a year. So I think that's a matter of consensus between everybody. So I think that's quite useful that it's retained. Chair, I think to Honourable Wright, I mean, I think for us it's...
But can I ask, in your view, is it clear enough?
I mean, we'll go through it again just to be 110%.
Yeah. Can you send us an amendment if you think... Sure. You see, that sort of thing we can negotiate with the NA. It requires 5 minutes on their side, right? We have done that before, where sometimes the staff of Parliament, or more usually the government department, human error, we had it to the Financial Sector Regulation Bill, you might recall, Dick, and the NCOP readily changed it and sent it back to us, and we just adopted it. So that we can deal with. But if it's at all unclear or ambivalent or, you know, not specific enough, we must change that. Okay.
No, thanks, Chair. We'll definitely do that, and then I think we'll talk to MP as well, make sure we're all on the same page. And you're right, Chair. Sometimes there can be a small little typo. We had that experience with the Unemployment Insurance Act a couple of years ago, which delayed the law by 3 years. So we can definitely do that. But I think it's positive that we're now kind of on the same page in that regard. So, Chair, just to Honourable Writer's questions. And I think for us, it's about rebuilding the trust between the auditing sector and those that are meant to serve and the workers and the public. I think for us, this is part of the process of cleansing the sector and rebuilding that trust. But I think for us, really, it's a question of what are the consequences for auditors? Are they being held accountable? And I think, to be honest, they're not. That's been a huge failure on us as a society. We all know about the looting at the parastatals at private companies. I don't recall any auditor, Comrade Chair, sitting in prison right now, let alone the assets being attached. Chair, I think just on the issue of the rotation, I think it's, as you said, this rule is there already, it's an internal rule. So if it's there, what is the resistance from IRBA colleagues or from Treasury about simply elevating it from an internal rule to a matter of law? I think that'll help to make sure that it's retained, etc. Our fear, Comrade Chair, is that bills take at least 5 years to process. And sometimes they can be completely forgotten. It can take an inordinate amount of times. Comrade Chair, we would know that Parliament passed the PIC Amendment Bill, for example, in March 2019. It still hasn't been signed into law. And there are many other laws simply like that as well. So that's a fear, that rather use the opportunity you have now. If there's agreement, do it, etc. It can always be tweaked further on down the road, but to kick the can down the road, if there's agreement that this is a useful intervention, I think for us would be a mistake. And I think, Chair, to separate that from the 5 years versus 10 years, I think for us, first prize really would be to get the mandatory rotation in law. And then if colleagues feel the 10 years is more realistic, fine, no problem. But I think the number one thing is to have it into law. And I think, Chair, also for us is a little bit of a frustrating point without being a broken record player, is that this issue was just raised not just by ourselves, but I think by other persons as well in the 2019 public hearings at Parliament. And I think our understanding at that time was that the bill was then kind of removed that time, I think, from the Financial Matters Amendment Bill for further consultation and because of the elections, timeframe, et cetera, et cetera. So it's a bit kind of disappointing that now, despite that additional year and a half, colleagues from government and from IRBA are still sitting on the fence, so to speak, with due respect. So lastly, Chair, I think for us, Parliament is the supreme authority when it comes to drafting and to amending and to passing legislation. As long as I think for us, the only thing which will prohibit Parliament from amending bills is if it's in violation of the Constitution, and clearly this wouldn't be a violation of the Constitution. It's simply elevating an existing rule into a matter of act, and there's plenty of precedents to do that. It's not irrational, etc. So I think for us, we would welcome if the committee was to do it. We would urge the committee to do it, and I think that wouldn't be an insurmountable issue to then send to the National Assembly for agreement as well. But yeah, let me stop there, Comrade Chair. Thank you.
Thank you, Matthew. I was bemused to hear that because of a typographical error, it took 3 years to sort it out. My God, I really think that's outrageous, really. I mean, honestly, 3 years to sort out a typographical error. That reinforces my view, you know, that this thing of, well, we'll bring it in the next bill. Can I raise something else before you respond to save time? I don't find it compelling, with due respect to you. I don't mean you individually, National Treasury collectively, that because you wanted to fast track the bill, you didn't want to introduce this 10-year mandatory rotation in the Act. Yeah, I can see, you know, that would help to get it fast tracked. But given the weight of this and the importance of this, it's even more important now than when we considered it as as an internal rule, if that's the term, or a semi-regulation of the IRBA. So, you know, I don't find that very convincing, but maybe you want to respond. Okay, over to you.
Chairperson, thank you. I just want to explain again the provision. Sorry, is it still, must I speak now, or is it first the member that must speak?
No, just give us a response, okay, because we've already spoken so far.
Okay.
And nobody's got their hand up. And really, we want you to respond to Treasury, to COSATU, and to perhaps what I said.
No. On the mandatory rotation rule that's currently issued, Section 10 indicates it must be published in notice any rule they make. And then there's a requirement when they make rules or amend rules that it must be published for public comment for a 30-day period. And after that, the rule or change the rule must be published in the Gazette. So that's the current provision in the Act. If the committee decides to make this amendment, I do believe it's outside the scope of the current amendments. And I just want to reiterate, I understand, I just explained the process that if we decided to include that in the bill that we tabled in February last year, we would have required to go through, as the executive, through a public comment process go through all the structures, and we have, apart from cabinet, we have a DG cluster process, which is quite extensive, and then to cabinet, and that's the reason why we decided not to include it. And we all along, the aim of the amendments was clearly set out to strengthen the powers of IRBA in dealing with improper conduct by auditors. So that was the gist of the amendments, apart from also dealing with the independence of the board itself. And I think that the only other concern we have is that if amendments are made now, but it's obviously entirely up to Parliament, it may delay these important amendments, not delay, but it will take longer before it becomes law. And IRBA is currently faced with a number of cases they're dealing with. Thank you.
Anybody else wants to come in? All right, can I ask you, Treasury, how does the slight delay in processing this bill, promulgating it, relate to the cases IRBA's got before it? I don't understand. In relation to the mandatory rotation of auditors, if we were to propose in a report to the House in COP that the committee on the other side actually amends this bill to put it in the, to put this provision in the bill, how would it affect the cases before IRBA?
Well, Chair, I will be brief, but just to indicate the bill now allows a different way of organizing the committees to deal with discipline more effectively. I don't know, Jillian, you want to add to that?
No, I don't have anything to add. Thank you, MP.
Frank, we had this situation in the last term of Parliament, and I believe the term before that, where Parliament raised this issue about how far amendments could go. I don't know if the legal services unit did that work or how it came to be, but there was a bill that was challenged by an individual member of Parliament because of the extent to which it was completely revamped. And it took up some policy issues that it was said were not considered when Parliament had the public hearings. And we had to refer it to, I think, your unit, Frank. And then you guys came back, I think, and said, well, no, it's not an issue. But there was some discussion. I can't recall whether it was the chairperson's forum about this, I think. I'm not sure, Frank, I'm a bit hazy. But I have never been convinced by that. But you see, that was a specific case, Frank. That provision was ideologically unacceptable to basically one individual there. It wasn't his other party members. I mean, I don't want to say publicly what they said. So, he made a big fuss about it, and he did it 2 or 3 times. You recall, Frank, you know what I'm talking about, right? So it became a bit boring. And, it was like actually a silly trick. It's like trying to filibuster. That's what it effectively was. So it lost its resonance. So I don't know. For example, now, if we were to go ahead and do this, could any of these auditing firms challenge us and say, well, it was not part of the original bill? Well, no. They can't say that, presumably. Or maybe they could. That the bill, you see, it's not our business, finally. As Parliament, we are sovereign and we are ultimately accountable for legislation. But this might help. You see, it's not about this bill alone. It's new members, even myself, and Kaleri for that matter. We need some clarity. So if we went ahead and did what Kosato is asking, which I personally think is correct, as I say, it's a tentative. We're having a brainstorming. I don't have a mandate. And I'm hoping the majority will agree. What's wrong in putting it in, right? If we were to go ahead, will we be challenged by one of the auditing companies that this matter was not processed through public hearings?
Chairperson, as far as I remember, it was raised in public hearings, but it might not have been part of the bill. So it would definitely, on the question, which one can look at from two sides at least. The question is not as clear cut, but the two sides that we can look at the question is there's a rule that needs interpretation, and that's applied with some precedent, and you referred to the precedent. That's the parliamentary rule that says if a committee goes beyond the scope of what is in the bill, it needs to get permission from the House. Now, that's one part of it, and that one deals with within Parliament. The public hearings itself, Chair, the clear example that we've discussed in legal services, what you've now said, and that was a court case on the application of legislation that regulates certain substances. And suddenly that became applicable to a veterinarian practice, and there was no specific public hearings on that part of the bill because it was a new matter. So that's the second part. It's the parliamentary rule and then public hearings on that matter. Now, this has been discussed, it has brought up and so forth. So it is there, Chair. I don't think that, Chair, actually, let me rather look at all the records before one just say that won't be a challenge to this if someone brings it up. It's always easier to err on the side of caution when it comes to new issues around the bill, to have proper public hearings, or just to ask people if they do want to put in more or comment more on the matter, if there's a 5-year rotation. So, Chair, that's on that point. I think the question is whether one can just elevate it and whether it becomes more or better oversight over IRBA if it is in the legislation rather than in the rules of IRBA. Chair, I think you've answered that question. That is for sure. I mean, at the moment, in terms of that Section 10 that my colleague, Advocate van Schoor, referred to, they can change it. There's a 30-day public consultation process. There's no committee process. I don't know how that process is implemented, but it's not the parliamentary process that we are used to when it comes to
we don't have a say. As I recall it, Frank, I think you advised us, or somebody did, that we cannot stop IRBA going ahead. So the hearings, we indicated, as I recall it, I don't know if Dicoleti recalls, we told auditing firms we can at best plead with them, IRBA, to negotiate further, but we can't stop it. I think you're right. Sorry, I didn't mean to interrupt you, but I'm just saying, it suddenly occurred to me, right? Is there anything else you want to say, Frank?
Chair, just a question of Mr. Ryder about the appointment processes. I mean, that is a policy matter. I mean, it's the principle of legality. Parliament must oversee an appointment process by the minister, then we must, and the minister must comply. If there's nothing said in the Act that Parliament has an oversight role over the appointment of members of IRBA, then we don't have a say. So it's a policy matter. One can put it in there, but there's no specific right or wrong. I mean, there is and I'm saying this not even with a pinch of salt, Chair. I'm saying it because it's obvious. There's an appointment process in Parliament to make it multi-party, not to make it unpolitical. It's always political, but it's a multi-party process rather than an executive process. That's why we have oversight over certain appointment processes, like with the Chapter 9 bodies, Chair. But that's a separate thing from smaller or other institutions which also do oversight, or regulatory bodies like IRBA and so forth. But that's it, Chair. Thank you very much.
Okay, any other comments, please? Okay, then in that case, Kosatu, I was going to ask you, Matthew. So one of the things we have to take into account, let me once again say, Matthew, my own view remains, tentatively, unless one's convinced otherwise by colleagues and comrades, that we should put it in the bill. So for me, that's not an issue. Secondly, I'm not convinced that there would be any legal challenge. I recall what Frank is saying now about the court case, but in fact, we had the situation of a single MP who was very unhappy ideologically or policy-wise with a provision in the financial sector regulation, and he took it to the chief work. But I was called in, and Mr. Casso had to come in, and I remember all of that, Frank. I think you were conferred with it. So it happened 2 or 3 times, I think 3 times. But it's like the boy cried wolf, so to speak. So I'm not convinced it applies to this situation. I think you're right. It was discussed in Parliament. It was there in the NA process. COSATU did raise it there. I don't see a problem as far as that goes. It's not outlandish. We're not now saying that URBA should be having a board that has got 5 COSATU representatives and 5 Communist Party representatives and 3 experts. Right, so now that's outlandish. Well, it's not outlandish, but what I mean is in terms of the rules of Parliament and so on. So I'm using a facetious example before somebody misquotes me or something. But the point I'm trying to make is that doesn't actually, I think, that concern is not that, for me, formidable, worrying. But the point I think we also have to take into account, Matthew, is this bill. We very reluctantly agreed to forego the provisions in the Financial Matters Amendment Bill, as you'll recall, that relate to URBA. Because you remember the temperature was very high at that time, with a series of major problems with the auditing firms. The Gupta leaks were out at the time. There was the VBS crisis, and so on and so on. So we wanted it processed. It was only the NCOP committee that decided, nope, they ain't going to do it, because they felt that it was pushing them, and they negotiated with us and we had to give in. And in fact, I think the chief whip on both sides met on this matter, as I recall it, and it was agreed. I was told by Comrade Mtembu, if I recall, that, look, it's no use pursuing it further. I think Tandi Modise, the House Chair also of the NCOP, put a foot down. And they had a good case, mind you, because we would have finished the bill, but they would have had too much to do. And URBA's provision, or the bill that we had then, the legally contested issue, colleagues, for those of you who were not around then, was over the search and seizure, which I fully supported. Was there in the FICA amendment bill. But, there were huge legal arguments against it, and I'm pleased that that's fallen away now. And I fully agree with you, Matthew. Search and seizure. What everything you said is, what have you to hide if you're doing nothing wrong? And then it's come to a situation where many auditing firms, you have to just take it that if they're accused of it, they probably are guilty. I'm not saying in all cases, right? But they probably are guilty, given what's going on in this country and the levels of corruption and the role of auditing firms in that regard. So look, I don't want to ramble on. I'm simply saying, can we all mull over this? We're not taking a policy decision today. I think we need to balance this thing which I was saying is that we promised URBA, look, many of us won't be back. Well, who thought, in my case, I would, but but we will put some pressure on the committees, wherever we are, to say, guys, we promised. Doesn't matter, we're not there in Parliament anymore, but it's a parliamentary committee that decided. And we put it, if I recall correctly, in our exit report. Please expedite it. At that stage, we are told the bill can be brought back in October or something. Right. So having said that, colleagues, I would suggest, can we exit from this public hearing, and can we go clause by clause to the bill, which I understand you didn't do last week, which is fine. You did the broad policy issues. And because, we don't need to belabor and feel good that we spent a lot of time on a bill where, in fact, most of the issues are not controversial. We can start signaling our policy take on the particular clauses. So what we're going to do now, colleagues, Matthew, if you want to stay, it's good, but, I'm sure you've got more productive things to do. We're not voting on the bill. At least I can't see that we'll vote on it in the next meeting. We'll put it all together and then we'll do a report after that. So thanks, Matthew. Now let's start with the bill, MP, clause by clause, and you take us through each clause and members will comment. Now, it's quite difficult. Look, I'm not that good at ICT and all that. Will you just keep interrupting and say so-and-so's hand is up? Because it's cumbersome for me to press that and so on. And you can connect with the management committee, I suppose. I'll open my WhatsApp here. we have a management where the two chairs, well, in this case it's one chair, we get told who wants to speak. Right. So Nkululeko can also send me WhatsApp notices to say, okay, Mr. Ryder wants to speak or whatever. Okay, having said that, can we move on to the bill? Colleagues, you were sent the bill again yesterday. Can we move, please, MP?
Chair, I want to ask, do you want us to take the committee through the bill, or we are also prepared the text of the Act with the amendments as proposed by the National Assembly? What do you
Well,
prefer?
obviously the latter is better, but that was what I've got anyway last night and last week was the actual bill.
Yeah, we submitted both last week before the meeting.
Oh, let me see. Nkululeko, do you send us two versions of the bill?
Yes, Chair.
Oh, all right, sorry. Then we should look at the one that's easier. The one I got last night says B2B 2020 auditing, right? Then we got the program 2021, APA. Oh, I see. It says program 20. Oh, that's why I didn't realize. I thought that's our program. Oh, I see. Okay. It's a strange title, but anyway. No, it says program for public hearings. And then the third thing you sent us yesterday. When did you send it? Look, we got this.
No, yesterday, Chair, I sent the B2B bill, the one that I'm fighting now.
Oh, yeah, then that's the one I've got. Yeah.
Yes.
But there's no tracking there that I can see.
No, Chair, for the briefing last week beforehand sent the Act.
Oh, I wasn't
with
here
the
last
changes.
week.
Yeah.
Okay. All right. Fine. So look at the letter, please. No, of course, MP. Who would not agree with you? Yeah. Okay. It's the only thing we're agreeing on today. Yeah.
And also on the number of meetings. So my colleague, my colleague Elway Malautsi will do the clause by clause.
Sorry, Chair. Chair, sorry. Whoa. Before we proceed, Chair, you might be up to speed, but I certainly am not. I'm not sure if everyone else is. The document that we're going to be looking at, which one is it? When was it emailed to us, etc.?
Yeah, that's the puzzle I'm having. So now I'm looking at the screen because I think this was emailed to us last week. But last night, I got 3 documents and they were sent to me at 5:34 p.m. Right? Those 3 in Nkululeko don't have the document that's currently on the screen that's been put up by National Treasury. I got B2B 2020. Right. Then there's a program 2021 and then 2021 first term program. So last night you didn't send it, but I think you sent it last week.
Correct, Chair.
Sorry, correct?
Yes, correct.
My brother, if it's not too much of a hassle, can you send it now to all of us? We're in our homes, presumably. But to me, it doesn't matter whether you're sitting on the beach, as long as you're connected to this. It's virtual reality. I mean, virtual meetings. So I don't care where you are. Well, wherever you are, you connected, and that's great. Now, you're going to send the bill to us, right?
I just
the
did.
Version of, oh, you did. Great. Okay, in that case, colleagues, in the meanwhile, can our colleague from National Treasury go ahead, my friend?
Okay, I will start now. I'll just assist people. Okay, thank you.
Mine's come through now. Thank you.
Okay. Good morning, Chair. Good morning, honorable members, and thank you again for the opportunity. Nkululeko, I'll just indicate when you need to move down. So you can move down. The first amendment is in section 1, which is the amendment of the insertion of the definition of constitution. If you can just move down. There we go. Down again. There. So that's the amendment in clause 1, which is an amendment of section 1, which inserts the definition of constitution. The reason for that is that in the current act, there is reference to the constitution, but there was no definition of what that word means. So it was just to clarify that any reference to the word constitution in the act actually mean the Constitution of the Republic of South Africa, 1996.
Okay, any comments on this, colleagues? Hands up those of you thought this is the Constitution of the former Soviet Union. Nobody. Oh, all right. So you see, my friend, I know you're lawyers and you have to do this, right, my friend? But to me, it seems so trivial. But I know you'll keep doing this now. I'm sure nobody thought it's anything apart from the South African Constitution. But my friend, you are doing what you have to do, right? As an official of National Treasury, managing bills. That's fine. Okay. Does the DA have a position on that, Dennis? Okay, the DA is going to have a caucus. Sorry?
As long as we don't amend certain parts of the Constitution, Chair, then I'm happy.
How does it follow? Okay, my friend, can we go ahead? Next one.
Thanks, Chair. The next amendment is in clause 2, which is amendment of section 4 of the Act.
Yeah, there we are. Sub 3, yeah.
Sub 3. So the proposed amendment requires the IRBA to determine a regulatory strategy with the approval of the minister. Members would recall, some members may recall that at the time the bill was introduced in 2020, there was reference to IRBA determining a policy with the approval of the minister. So that has now been changed through the National Assembly process. So it's no longer a determination of a policy, but it's now a regulation of to determine a regulatory strategy with the approval of the minister. So the clause also provides a process that must be followed by the minister when that regulatory strategy is determined, and it also requires that it be published in the Gazette once it is made, and any amendment thereof, it also requires that it be published in the Gazette. That's clause
this
2,
one,
amendment of section 4.
We just move a bit further down because we're on 3 still. It's in 4.
It's in 4. You just passed it. So what I was explaining is that the amendment that you would.
Can I suggest? Sorry, I didn't get your name, my friend. Well, what is it?
It's Aire Muraudzi.
Right. Okay. Now, can I ask you a question? Right. This can you speak a bit slower because I'm a bit lost, right? What this reads and what you're saying doesn't seem to correspond, unless it's also linked to some other clause. Or have I got it wrong?
No, that's what I was trying to explain. That yeah. when the bill was introduced, this is the provision that we had, right. And when the bill was considered by the National Assembly, then there was an amendment made, which now makes reference to determination of a regulatory strategy, which is what you would now find in Bill 2B.
Okay.
Sorry, Chair, can I interject? I just want to check, Elway. I thought we included all the amendments from the National Assembly, because this seems to be the original.
Yeah, it's maybe one of those oversight things that we missed.
Yeah, but it's in the bill what Elway explained, so my apologies, Chair.
Yeah, I'm terribly confused, really, what you are saying, but I really don't know what you're saying, actually, the two of you. Do other people understand what's being said here?
Definitely not, Chair. Can
Okay.
I come in?
Maybe just explain, this provision is, as it reads now, was as the bill was tabled in the National Assembly, but the National Assembly made changes where it's now called the regulatory strategy, and there's a process to develop it. And we actually made an error when we prepared this text. We didn't include this in the text, so I apologize for that.
Yeah, but this is worrying, MP, you know what I mean?
Yeah.
No, but the amendment.
I mean, we thought we'll finish this bill basically today. We'll allow anybody who wants to mull over it for a week, and then we vote on it, if possible, next week, or certainly. Can I make something clear, colleagues? The aim is to finish the bill next time we meet. Only we may not have a report. So the following meeting is just a cursory one, which is, here's the report now, and let's vote on it, okay? Takes 5 minutes. So basically, we'd allocated one more sitting because it didn't seem when I originally led the bill that, okay, so let's look at where we are. Where are we now? We're at, what's the date today? Today is the 9th, right? Next week is consideration of policy issues. And then, yeah, on Thursday, the Thursday meeting is actually just to vote on the bill. Am I right, in Kuleleko?
Yes, Chair. Sorry,
So what I'm saying is, as I understand it, next Tuesday, we'll finalize everything, right? And then on Thursday, we're just going to adopt the report. That's a 5-minute meeting. So we've allocated one more meeting. So this one, can we defer until you guys sort your act out, right? But it's making us feel a bit like, losing confidence that it's so easy to deal with. Frank, can you help here as well? Because you speak for Parliament, right? Treasury can say what it wants, but ultimately it's Parliament that decides. So I would suggest, Frank, that you engage with our 2 colleagues from Treasury, and we would like your opinion on what they're doing here. Okay? All right. Is it agreed, Frank? Frank?
Yes, Chair, I hear you.
You engage with our 2 colleagues, and then you tell us, okay, once they speak again next week, that look, yeah, this is what I think is correct, okay? Right, so let's leave this clause out in suspension. I don't think we need to take any decision on it, tentative one, though it may be. Okay, over then to my friend, to the next one.
Chair, I'm sorry. Can I interject, please?
Yeah.
Chair, it's problematic for me that we're sitting with a document in front of us that is not the document that we're supposed to be considering.
I thought it's only this provision. If that's, let's check if that's the case. Friends, Treasury, are you saying that this is a wrong document altogether, or are you saying that that particular provision is the wrong one? It's not complete. Or is the bill before us as a whole, as Dennis and Mr. Wright is suggesting, not the one that should be before us?
The bill is the correct one as passed by the Assembly. So I don't know, Elvis, if you want to explain on the text that we prepared.
Yes.
It's normally not voted on. The bill is voted on.
I don't understand what you're saying. Sorry,
if you can explain what the difference is between the bill and the text. I mean, the text is the bill. I don't understand the difference. Please.
Yeah, what are you saying, MP? I don't understand.
Because like you did in the Standing Committee of Finance, you asked us to prepare the act showing the amendment, so it's easier for members to read, and that's what we did. And then we picked up in this particular provision, section 4, that was amended or proposed to be amended. We didn't indicate the National Assembly amendments, but as far as we know, we did include it in all other instances. But we can double check. But what, in the end of the day, the B bill that's before the committee, that version is correct. But if you want to proceed as using this act showing the proposed amendments, we will just double check every time. When I will present, I'll check that it does have the National Assembly amendments.
Okay, fine. I think I understand you now. In which case, Frank, can you double check, so to speak, and Esther and Poppy? Esther and Poppy, are you here?
Yes,
Esther is here, I can see, yeah. Okay, so can all 3 of you just check this out, okay? All right, thank you. Okay, can we go ahead, colleagues?
Thank you, Chairperson. We can move to clause 3, amendment of section 11.
Clause 3 does say establishment and legal status, isn't it?
Amendment. Clause 3 of the bill, section 11 in the Act.
Oh, section 11 in the Act.
We still need to go down.
Okay, yeah, section 11. Yeah, say section 11 of the Act. Okay, good.
Okay. So the proposed amendment there is to prohibit registered auditors and registered candidate auditors from being appointed as members of IRBA. It also proposes the amendment that prohibits members of the IRBA from sharing directly or indirectly in any of the profits or interest of a registered auditor or any person related to a registered auditor, or from receiving payments, excluding pension benefits, from a registered auditor. So the proposed amendment also provides for the increase in the board of representation of formally registered auditors and legally qualified persons from 1 to 2.
Okay, colleagues, any comments? Any comments? I would like to read this and so on properly. I'll need more time, but is there any member wants to ask anything right now? All right, can we move on to the next one, please?
Amendment of section 12.
Right.
So the proposed amendment there is to provide for members of ERBA to hold office for a period not exceeding 3 years. That's the,
what was the rationale for this? What was the rationale for this?
The rationale for increasing the number from 2 to years, it was felt that 2 years it's actually too short for anyone to come in and make a meaningful contribution as a board member.
Yeah. Okay. Anybody got anything to say, colleagues? Nope. Can we go on?
Next one is amendment of section 14.
Yep.
The proposed amendment there is to increase the term of office for the chairperson and deputy chairperson of the disciplinary committee from 2 to 3 years.
Yeah, that's consistent with the earlier one, right?
Yes,
yeah.
Correct.
Okay,
correct.
Good. I don't think we'll have a problem with that. Nobody's raised an issue before. Go ahead, my friend.
The next one is amendment of section 19. It's just a technical amendment to deal with, to correct the cross references and also to insert references to the enforcement committee wherever it's appropriate. So that one is a technical amendment.
Okay, here, cross-referencing, Frank, will you check that out? And Esther can just be supportive there because, sometimes, Frank, we're human, so we could miss it. So Esther, please help in that regard. Just check that the cross-referencing is correct because we just heard what Matthew said. They had a typo and it took them 3 years to fix. So, and Treasury and other departments have sometimes got this wrong. So Frank, please check this, and Esther, please help and also independently check that. Okay. The next one, my friend.
The next one is the amendment of section 20, which is also a technical amendment. It proposes to delete unnecessary references to the number of times the committees must meet.
But what is the policy meaning of those words?
What is the
policy? In other words, you're saying that it removes the technical issues related to the number of times it meets. Okay, fine, by cross-referencing. But what is the consequence of that? It means the committees can meet as and when they want, or what did you do here in effect?
What we actually did in effect there is to try and deal with the confusion that existed in terms of how many times the committees should meet. Because as MB indicated earlier, when she dealt with the issues of how many times the board must meet, there was always that confusion as to the reference in section 15 and the reference in section 20. While section 15 dealt with meetings generally, you also had a reference of committee meetings under 20, which we felt was unnecessary. And that's what brought the confusion. So we're trying to make sure that this is only dealt with in one provision, which is 15.
Okay, colleagues here, do you want to say anything? Look, Frank, Esther, can you check that this is what it says it is? Why, my friend, I want to ask you something. Why can't we just say simply, like we do in other bills, the board must meet at least 4 times a year. At least obviously means that it could meet more times. And then have a clause, and committees must meet at least 4 times a year, full stop. What's the problem in doing it simple and plain? And then cross-referencing it. Like here, reading this.
Chair, may I comment?
This is dealing with like the need for transparency and representativity, and may appoint any person as a member of a committee on such terms and conditions as the board. I'm not sure where, my friend, it comes in that it's about the frequency.
I was referring to 25.
Sorry, 25.
Yes, that's where we refer to the issue of 4 times a year.
Oh, I see. Cross-referencing to 25. Okay, let's go to 25 and see.
25 speaks about funding.
No, 20 subsection 5. 20 subsection 5.
Oh,
not 25.
Okay. 20 subsection 5. Yeah, now here my friend is referring to committees, right? Where's the reference to board?
In section 19, Chair. Sorry, 15.
15.
Okay, so you're clear it's there, Dennis?
It is. It's clearly stated in 15.
Our meetings, yeah, that's right. Okay. So why did Kosato have it wrong then? Yeah, it's
They've
clear.
had it wrong on many issues for many years, Chair.
Ho, ho, ho. Oh, it's quite a big glitch there in Kosato's side, what I can see. All right, it's clear now, thank you. But we will have our team check this out, Frank and Esther, yeah. Okay, next.
Should I move to the next one? Section amendment of section 24.
Right, going to 24, yes.
Deals to provides the amendment provides for the IRBA to establish an investigating committee and also deals with the appointment of members of that committee. The amendment also regulates the conduct of members of the investigating committee. So the same principle that applies to members of the board in respect to prohibition to sharing of profits by members with either a candidate, an auditor. So the same principle also applies to members of this investigating committee.
Comments here, colleagues? Okay, next one, 24A.
24A proposes the amendment to actually the insertion. It's an insertion of section 24, which is the deals with the establishment of a disciplinary committee, and then the proposal is to provide for a power to IRBA to be able to appoint as many members of the disciplinary committee as it may determine. And the amendment again also further regulates the conduct of members of the disciplinary committee by, as I indicated, with regard to the investigating committee and members of the board, by prohibiting a member of this disciplinary committee from using his or her position to improperly benefit himself or herself or another person to impede the work of the committee. And the same principle in terms of sharing of profits with either with a candidate, with an auditor. So the same principle as it applies to the members of the board and members of the investigating committee would also apply to members of this disciplinary committee.
Yeah, okay, fine.
Proposed, the other important amendment is that it also allows IRBA to establish subcommittees, which may include a subcommittee called an enforcement committee, which would have the power to deal with certain categories of disciplinary matters of improper conduct by a registered auditor. And the issues that this investment committee may deal with would actually become more clearer when we deal with other amendments that are going to come later on.
Okay, thank you very much. Any comments here?
Yes, Chair, can I just check?
Yes, sure.
I just want to check here that am I getting it right to say that in order to qualify as a member, you must have a 10 years experience in that field?
Okay, any other comments, questions, please? Over to Treasury.
I take it that the member is asking whether for one to be appointed as a member of the ERBA board, whether you need to have 10 years experience. Is my understanding correct?
No, you are correct.
Okay. As you would see in the provision that deals with the appointment of board members, it allows the minister to appoint suitable members, but it also specifies certain categories of membership from different disciplines. That is from auditors and also from the legal profession. For those two categories, it requires that they must have at least 10 years experience. So if you are appointed as a member representing the formally registered auditors category, or if you are a member being appointed to represent the legal profession, then you would be required to at least have 10 years experience in the field.
Okay, that's clear enough. Maletsana, are you fine with that?
I'm covered, thank you, Chairperson.
Okay, all right, thank you. Sorry, go ahead.
The next amendment, Chair, is in section 36.
Section 36.
Yes, section 36.
All right, where are we now? Oh, yes, there we are. Yeah.
It's just a deletion, Chair, of a paragraph which has become obsolete. So it's no longer necessary or required.
Yeah, that's fine. Okay, is there anybody else who wants to raise anything? No, okay, can we go on, please?
The next amendment is in section 37.
Fine.
Yes, the amendment there is to prohibit the registration of an individual as an auditor or candidate auditor if that person has been convicted of an offense.
Yeah, fine, that's straightforward as I see it, unless somebody's picked up something. Okay, go on, please.
Amendment of section 39.
Go ahead, please.
Again, Chair, this is proposed amendment is also to delete part of a paragraph that has now become obsolete. So it's also a technical amendment.
Okay. Anybody got anything to say? Nope, right.
Amendment of section 41.
Yeah.
Again, here we proposing to delete a paragraph which has also become obsolete.
Right. But you've inserted a new paragraph there. Am I right? You've inserted a new paragraph there under B. You've deleted A in red and then B appears in blue.
It's B is not an insertion. The only insertion in B, it's right at the end.
Oh yeah, cross-referencing.
Yes, cross-referencing.
Oh yeah, obviously cross-referencing changes when you make. That's okay. No, that's fine, my friend.
So the next amendment is in section 45.
The other one that you've got is at D, sub D of 41 of 5, isn't it? It's 41, 6 D. Am I right?
Yeah, 41, 6D.
Yeah, you changed suspended, you made it to disqualified from registration instead of suspended from public practice. I think you mistakenly jumped over. Am I right?
My apologies.
No, it's not fine. No big deal.
I missed that, Chair. Yes, you're correct.
Explain the reason for this.
Let me just go to the paragraph. This a view that there is a difference between suspension from practice and disqualification from registration. So somebody who's suspended from practice, it may be a suspension for a particular period, whereas disqualification, you may not continue to practice the trade. So that's the.
Go ahead. Sorry, no, go ahead.
So that's the clarification we're trying to make by using the phrase disqualification from registration.
All right. So basically, here, am I right to presume that if you're suspended, you can be found not guilty of what you were accused of, if that's the case, that you're accused of something, and then you can be reinstated, isn't that right?
Yes.
But it could be a very long period between the time you are suspended and your process has been finalized.
Yes.
Ooh.
But when you're disqualified from registration, it means you cannot register.
Yeah, I know, but that can take a very long while. You know, how slowly they move and these processes. But fine, unless somebody can see something here. Personally, I'll let it pass, but yeah.
Eunice, William.
Yeah.
It can also happen that one is suspended for a period of 3 or 6 months or whatever, but still stays registered. So I think the purpose here is to be applicable on people that cannot qualify for registration anymore, instead of people that are registered but are under some sort of penalty for a certain period.
Yeah, no, I understand. I'm just asking about the practical meaning of it. But yes, it's very clear what both of you are saying. It's just that I wondered, well, fine. Can we move on? Let's just mulling over it. I've got a lot of time between now and next Tuesday to go very carefully through the bill, yeah.
Yeah, Chair, the next amendment is in section 45.
Yeah.
What this basically proposes is an amendment to prohibit the removal of an auditor before the auditor completes the process of reporting what we refer to as irregularities to ERBA, as envisaged in that section. So the amendment further proposes that where an individual registered auditor has reported an irregularity and he or she resigns from the firm where he or she is employed before completing that reporting, the auditor must do the necessary handover to the incoming auditor regardless of when the resignation takes effect. Maybe just by way of trying to explain what it means in practice. It happens that when an auditor is busy conducting his or her work, they do come across certain irregularities for which they have an obligation to report to ERBA. So what this amendment does is to prohibit a firm from removing that particular auditor before he or she completes the reporting process. And in the event that the auditor decides to resign from the firm, at least there's an obligation placed on the auditor to make sure that the necessary handover is done to the incoming auditor so that the reporting process is not left hanging.
Fine. Anybody wants to comment on this?
Just one question in terms of practicality, if I may. The Act doesn't place, or the bill doesn't place any responsibility on the incoming auditor, or doesn't comment at all about the incoming auditor and how they must deal with it. Obviously, there's a code of conduct and so on, but I would have just, I don't think it's life-changing, but it's just that it would have been nice to see that the incoming auditor would need to act on the disclosures made in the handover process.
Okay. The response from Treasury?
Can I ask maybe our colleagues from maybe MP if you have any input to make on the matter, or Gillian?
Gillian, I would suggest. Yeah.
Gillian?
It is covered in our Code of Professional Conduct, and that as an incoming auditor, your responsibility is to specifically request from the outgoing auditor whether there are any reportable irregularities currently in progress. So it is covered in our code.
Thank you.
Yeah, I would have thought it's a norm. It's like a commonsensical thing and so on. but also I can understand, given what's been going on, as you'll appreciate, Gillian, that Mr. Ryder raises what he does. Okay, fine, that's useful, Dennis. I mean, I just took it, but when I think about what you're saying, it strikes me it's not so straightforward. Okay, can we go on, please? I think it's 48 that's next, right?
Yes, the next one is 48, Chair. And you would recall that I indicated earlier when we were doing, I think it was the amendment regarding the establishment of ERBA's power to establish other committees. And I indicated that one of the committees that ERBA is now empowered to establish is what we call an enforcement committee. And I did indicate that later on, we would indicate amendments that do talk to some of the activities or issues that